Bar TV, voice of the voices.
Supreme Court so ena onyonyamfo Aban Bagbin ne lawyer ekire se ebeya enka asam no Supreme Court enye den entwensan enso Supreme Court esi debi asam we yegitumu a enye yie yenjintumu ne enjintumu china yankonkwohwe video no.
According to the plaintiff, the Speaker's interpretation of Article 97(1)(g) was wrong because he, the plaintiff, also interpreted Article 97(1)(g) as affecting members of Parliament who wanted to change party affiliation. He also interpreted it as affecting the status of parliamentarians in the next Parliament and not while sitting in the 8th Parliament. These and others are the disputed interpretations that the plaintiff presented to the Supreme Court to give the nation the correct meaning of. For the sake of the record, we set out Article 97(1). A member of Parliament shall vacate his seat in Parliament upon a dissolution of Parliament, or if he is elected as Speaker of Parliament, or if he is absent without permission in writing of the Speaker and he is unable to offer a reasonable explanation to the Parliamentary Committee on Privileges from 15 sittings of a meeting of Parliament during any period that Parliament has been summoned to meet and continues to meet. Or D, if it's expelled from Parliament after having been found guilty of contempt of Parliament by a committee of Parliament, or E, if any circumstances arise such that if he were not a member of Parliament would cause him to be disqualified or ineligible for election under Article 94 of this Constitution, or F, if he resigns from office as a member of Parliament by writing under his hand, addressed to the Speaker, or G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member, or H, if he was elected a member of Parliament as an independent candidate and joins a political party. 2. Notwithstanding paragraph G of clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitution or membership of a coalition government of which his original or political party forms part shall not affect the status of any member of Parliament. Now, clearly, with the disputed interpretations alleged in the plaintiff's statement of case, even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex-parte Zaneto Rawlings, to refer these contested meanings to the Supreme Court to determine the correct interpretation. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of Parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seats of a member of Parliament and the Speaker. It does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself. We have considered the objection to the procedure used to serve the Speaker because of the administrative circular of the Chief Justice in 2021 and 2024. We are satisfied that administrative procedures cannot override the potency of legality, and every procedure used by the Supreme Court to serve the processes on the Speaker of Parliament were actually in conformity with law and the circulars issued by the Chief Justices in 2021 and 2024. Exercise of discretion. The Speaker of Parliament is urging that the Supreme Court breached the rules of natural justice and rules prescribing the manner for exercising discretion in the orders made on 18th October 2024 in hearing the application ex parte and granting orders to stay execution of the Speaker's ruling pending the resolution of the suit. It is a very basic and primary principle of law that an order of stay of execution must be made on consideration of exceptional circumstances that can affect the parties, which exceptional circumstances include the wreaking of irreparable harm if an order of stay of execution is not granted. In the ruling of the Supreme Court on 18th October 2024, the Supreme Court was very clear that its orders were being made because of the exceptional circumstances that would flow from the effect of the ruling of the Speaker of Parliament declaring the 4 seats vacant and a determination not to allow the MPs to remain in Parliament. What are some of the effects that weighed on our minds as exceptional circumstances that were alluded to in the ruling? The 4 constituencies of Amenfi Central, Fomena, Aguna West, and Suhum in the Western region, Ashanti region, Central region, and Eastern regions of Parliament are made up of hundreds of thousands of Ghanaians who had queued to elect these members of Parliament to represent their interests in Parliament as their voices. By declaring that their duly elected representatives in Parliament had vacated their seats for acts that were interpreted within the light of Article 97(1)(g) by the Speaker was actually enforcing this interpretation of Article 97(1)(g) against those hundreds of thousands of Ghanaians, and not just the 4 people that sit in Parliament. He was also doing so at a time that from the official records of Parliament presented to the Supreme Court, the Speaker knew that a contrary interpretation was being placed on the same constitutional provision and that the Supreme Court's jurisdiction had been invoked to provide the correct interpretation. By reason of law, there could be no by-election to replace these elected representatives between 17th October 2024 and 7th January 2025. So, 7th January 2025. 2025. So these Ghanaians would have been left without a voice and representation in Parliament from 18th October 2024 until 7th January 2025, when the 9th Parliament can be duly constituted in Ghana. This exceptional circumstance arising from the outcome of the ruling weighed on the mind of the Supreme Court to grant an order directing a stay of execution of the ruling of the Speaker on 17th October 2024. Second, the effect of this ruling would be that the salaries, allowances, and other emoluments of these members of Parliament would have had to stop being paid immediately. They would have had to vacate their offices in Parliament and cease functioning on any committee of Parliament that they were serving on. If any of them was a minister or deputy minister and had been appointed as such by reason of being members of Parliament, the ruling that they had vacated their seats could have brought those duties to an immediate halt. Indeed, one of the 4 members of Parliament is the current second Deputy Speaker of Parliament. The Supreme Court was very clear that these outcomes that could cause irreparable harm to the constituencies in issue and the MPs themselves constituted exceptional circumstances to warrant a halt of the ruling of the Speaker until the controversy raised had been resolved. The consideration of these exceptional circumstances was clearly spelled out in the ruling of 18th October 2024. So it is surprising that the applicant should urge that the discretion of the Supreme Court was exercised in breach of Article 296. So why did the Supreme Court grant orders after hearing this application ex parte or without notice to the Speaker of Parliament? Once again, the ruling stated the reason clearly. The official records of Parliament for 17th October 2024 was placed before the Supreme Court as an exhibit. The record showed that the processes of court had been served through the legal department of Parliament, and this had been brought to the notice of the Speaker. He bantered extensively on this information with the plaintiff on the floor of Parliament. And the Speaker's only reason for choosing to quarrel with the summons from the Supreme Court, an application for injunction to restrain him from ruling on a matter premised on interpretation of Article 97(1)(g), was that as Speaker, he was only supposed to be served with court processes on Monday. This is an unfortunate interpretation of the first column of the circular referred to, because this circular provides for the Speaker of Parliament to be served personally on Mondays and through the legal department of Parliament on any day. But whatever interpretation of the circular that the Speaker chose to put on how he was to be served, the Supreme Court is satisfied that the Speaker was well served with notice of the action that had been started on 15th October 2024 and seeking the correct interpretation of Article 97(1)(g) of the Constitution. He was well served before he delivered his ruling on 17th October 2024 that would lead to the exceptional circumstances enumerated herein. And the Supreme Court carries the constitutional obligation to give the correct interpretation of Article 97(1)(g) for its enforcement, if need be, by the High Court or any person that the interpretation comes to. Hence, the scope of the orders made to stay enforcement of the Speaker's interpretation of Article 97(1)(g). Grant of orders beyond 10 days. The Speaker's lawyer urges that because of Order 25 Rule 18 of the High Court Civil Procedure Rules 2004, CI 47, that enjoins high courts to grant injunctions and other preservation orders for 10 days in the first instance if heard ex parte and without notice to one party summoned before the court. The Supreme Court was also enjoined to grant the ex parte order for 10 days as a matter of rules and practice. This is a submission that fails to appreciate the import of Article 2.2 and 2.3 and 2.4, which guide the Supreme Court when dealing with a constitutional matter such as this. We will quote again Articles 2.2, 2.3, and 2.4. The Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to declarations so made. Any person or group of persons to whom an order or direction is addressed under Clause 2 of this article by the Supreme Court shall duly obey and carry out the terms of the order or direction. The Constitution enjoins the Supreme Court to make orders that are appropriate for giving effect or enabling effect to be given to its final declarations on the correct meaning of a constitutional provision. And the Constitution is so serious about ensuring the obedience of such orders that it creates the offense of high crime for failure to obey such orders in Article 2.4. Not even the President and Vice President are exempt from obeying the orders of the Supreme Court when they are made to give effect to its duty to prevent a violation of the Constitution. Because of the irreparable harm to the constituencies made up of hundreds of thousands of Ghanaians who would have lost their MPs without the option of a by-election, and the irreparable harm to the MPs who would have lost their seats in Parliament in these last few weeks to the 7th December elections, if the meaning put on Article 97(1)(g) by the Speaker was enforced without a clear determination of the disputes around it. This court found it expedient to compel the parties to allow an early hearing rather than make an order that would last only 10 days. This is the reason for the Supreme Court's orders abridging the 14 days allowed for defending a constitutional action through a statement of case and directing the parties to file their respective statements of cases within 7 days and present the issues for resolution immediately thereafter. If the parties had complied with the court orders, this would have taken all of the 10 days the applicant urges an ex parte order ought to last. Compliance would also have enabled this court to dispose of this case by this week, including the question of whether the suit is competent in form or the jurisdiction of this court has been properly invoked. It is important, and the question of whether the jurisdiction has been properly invoked is different from whether the jurisdiction exists. It's a different legal question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused.
Lord, we are extremely grateful. Ask the court, please, Ismail.
So, Mr.
Not so grateful.
So, Mr. Sorry, will you be filing anything? Or should we hear without you?
Oh, no, I don't have instructions on that matter, but especially so that if my lady looks at the affidavit that I filed, I said the order was served on the Speaker on Monday. So he has 7 days. I will speak with him to draw his attention to the court's ruling. And then,
So it was served on him on the order was served on him on Monday.
that's Monday.
Monday was 29th.
No, last Monday is the 20th.
Monday, just around 2 weeks ago.
No, wait.
No.
On the 20th.
It was-
It was on the 20th.
On the 20th.
No,
And today is
21st.
the 30th.
21st. It was 21st.
So he's gone past the 7 days.
No, but if he served with the order on that specific day, telling him to file within 7 days, it takes effect on the date of service. That is my understanding.
So he was supposed to file by 28th.
No, by the rules of the court, where the time limited for doing something is 7 days or less.